Hello and welcome to Auspol Explained. I'm your long curly haired host David, and today I'm wearing my Mothman t-shirt because we're about to get a little bit conspiratorial. Now, it's understandable that not everyone has a good idea of how the Constitution works. It's, a dedicated subject, but sometimes people's ideas of it are just downright very absurd. And as someone who creates lots of political content and educational content, I get some very weird comments claiming some very absurd things. Now, instead of just me responding to them, who am I? I'm just a guy. I'm sitting down on Zoom with a constitutional expert to respond to them instead because, why not? Could you please introduce yourself?
My name is Anne Twomey. I'm a Professor Emerita at the University of Sydney. My specialisation is constitutional law.
We're both sitting in front of an impressive bookcase full of political books. Yours a little bit more impressive. We might have to reference some of those in our journey to debunk some constitutionally nonsense comments.
If you look at these ones up here, they're the Constitutional Convention debates, so they're terrific. These ones down here, mostly books that I've written, at least those ones are there, so they're very important. These ones over here are state constitutional law books. These ones up here are constitutional history books. And up there's like politics ones, so you can probably see a little bit of Odgers and House of Reps practice and all the rest of it. So yeah, lots of useful books.
You have a YouTube channel, Constitutional Clarion, where you talk about the Constitution, and you've probably / definitely got some similar comments to me. So let's debunk some of the weirder claims that we've gotten. First comment: there are only two levels of government in the Constitution, state and federal. Therefore, local government is not a level of government, but actually a corporation with no authority, and any council law can be challenged in a court of law. On top of this, the public rejected the existence of local councils in the Constitution in 4 referendums. What do you have to say about that one?
Okay, well, for starters, they can't count, but we'll get back to that one. Okay, so the underlying truth is that the Constitution itself does only recognise Commonwealth and state governments. So to that extent, it's true, but the Commonwealth Constitution gives states what's known as plenary legislative power, and that means they've got the power to make laws about anything unless the Constitution takes it away from them. And so what the Constitution did was gave the state parliament's power to establish local government by legislation, which is what they've done. And indeed, local government had existed before federation. The people who wrote the Constitution were expecting there to continue to be local government, but operating as a creation of the states. Now, as to whether or not local government is a corporation, local government itself, as institutionally, is not a corporation, but different local government bodies, like councils, in some states are treated as corporations, and in other states are not. They're treated as part of the Crown, so that's a matter for the state and what legislation it establishes. What impact does that have on councils and local government bodies and their ability to make laws? Well, again, it comes back to the state legislation. So the state legislation confers power on local government bodies, whether they're a corporation or not, to create bylaws. And so long as the bylaw falls within the scope of that power, then it's valid. And yes, you have to obey it because the law requires you to do so. And finally, the public did not reject the existence of local government at 4 referendums. 2 referendums have been held on the subject, and for some of you, you might remember that there was a 3rd that was going to be held, but it got chucked out when Kevin Rudd replaced Julia Gillard and decided to have an earlier election. So that one wasn't held. But in any event, neither of those referendums was directly about whether or not we should have local government. The first one was about the power of the Commonwealth to fund directly local governments. And the second one would have created a guarantee for the continued existence of local government, but it would still have meant that the states were the ones that created and maintained local government. So, yeah, definitely wrong on that one.
The existence of local government causes some people just so much frustration for some reason. The next one is Gough Whitlam stopped schools teaching the Constitution in the 1970s because he secretly changed it from the red Constitution to the green Constitution, which is naturally a false constitution. The red Constitution hasn't been abolished, but is being hidden from the public. On top of this, Gough Whitlam's new constitution is his own version based off maritime law, which classifies Australians as nothing but cargo.
Okay, it's hard to know where to start with that one. First of all, as you do know, I have done a wonderful video on the colour of the Constitution. So anyone who really wants to know that can go out and have a look at it. Interestingly, when people run this argument about the green Constitution and the red Constitution, etc., they tend actually not to be referring to the Constitution itself. They're referring to a book about the Constitution, which is this book. See if I can reach it. Okay. It's a book by a couple of people called Quick and Garran. It's the Annotated Constitution of the Commonwealth of Australia. It's a great book, written in 1901, but it's never itself been updated. So the 1901 version, and indeed if you look at that one up there, that's actually the one published in 1901. So it's that is an original binding. But when it's been reprinted, it's exactly the same. So what is in this version, which is a reprint of it, is exactly the same as what's in that version, and exactly the same as what's in the green coloured binding and every other coloured binding. Okay. So the book itself is a 1901 book. It's about the Constitution, but it isn't the Constitution itself. Now, here is the Constitution, and if you look at it, the Constitution is really thin. Okay, that's how long it is, and that's the longest version because this one has the really good index in the back. So if you take off the index and the Statute of Westminster, Constitution runs for all of 36 pages. Okay, it is not long. If you have a look at this book, which is the one everybody talks about saying something's in the Constitution, this is more than 36 pages, okay, because it's written about the history of how the Constitution was written and the convention debates and the US Constitution, a whole lot of other things. Okay, so that's the start of it. Let's dispel the argument about the red and the green and the whatever. That's all irrelevant. Did Gough Whitlam stop people from teaching about the Constitution? No, he had no power to. He didn't control what the curriculum was in any of the schools, but it is true that teaching of the Constitution and government in schools is abysmal, but has been for quite some time. Third point here is that whenever anyone makes that claim about what's sort of magically different and got changed in the Constitution at the time of Gough Whitlam, no one actually can ever show you what the differences are. The Whitlam government did try to amend the Constitution with referendums in 1974. All of them failed, so it never managed to make a change to the Constitution at all. So yes, the last constitutional change was in 1977, so after the Whitlam government. But if you look at any copy of the Constitution, it only contains the formal changes that were made by referendum since then. And finally, the Constitution is not based on maritime law. Heaven only knows where that one came from. But hey, just read it. You can look at the Constitution. It's not that long. You can find it on the Commonwealth Parliament's website. You can find it on the Federal Register of Legislation. And there are many places on the internet you can find it. So if you really want to read and find out whether it's based on maritime law and whether you're actually cargo, then my suggestion is just simply read the Constitution. You'll find out it's not true.
The Parliamentary Education Office, peo.gov.au, also provides copies of it. Just to illustrate how the Constitution is not very big, I have like a pocket version where the pages are about the size of my hand. It is 58 pages, not a very big book. The cover of this one, surprisingly, is blue. So I don't know how that fits into the conspiracy, but I mean, blue like the ocean, like maritime law. It's all coming together.
Maybe that's the answer. I don't think I've ever seen a blue Quicken Garren, so who knows?
Let's move on. This one's quick and simple. Western Australia is not mentioned in the Constitution at all.
Ding, wrong. I think the source of this one, a lot of these things have some kind of underlying truth. So the underlying truth in this one is that Western Australia is not mentioned in the preamble to the Constitution. And that is because the Constitution Act, which is the British Act that our Constitution is contained in, so our Constitution is Section 9 of a British Act of Parliament, and that British Act of Parliament has a preamble, and the British Act of Parliament was actually passed in, I think it was July 1900. And that was before Western Australia agreed to come in as an original state. And so when the Constitution was passed, they weren't sure whether Western Australia was going to come in or not. So Western Australia is not mentioned in the preamble, but it does get mentioned in some other clauses where they had to accommodate two options. One is Western Australia is there at the beginning, one is that it's not. So you can, again, have a look at the Constitution and you can see. So there are some references in it to Western Australia. One is in Clause 3 of the covering clauses, so that's the bit in the British Act, and it states that if Queen Victoria is satisfied that the people of Western Australia have agreed, she shall make a proclamation establishing that the people of New South Wales, Victoria, South Australia, Queensland, Tasmania and Western Australia shall be united in a federal commonwealth under the name of Commonwealth of Australia. And so that's what happened. Also in covering clause 6, which defines the states, it does list in there Western Australia, as well as New Zealand, by the way, because they were keeping their options open as to who might join. New Zealand didn't join, as you would know. And it just says, well, it's these colonies, so long as they're the ones that join up. And Western Australia did join up, and therefore it's mentioned there. Western Australia is also mentioned in the Constitution itself, in section 26, where it sets out that the initial allocation of seats amongst the states, if Western Australia becomes an original state, which it did, it lists them there, and it lists them if Western Australia isn't. And then finally, section 95 also gives a special deal for Western Australia in relation to customs duties that are collected in Western Australia during a transitional period at the beginning of Federation. So all up, if you do a Google search on the Constitution for the number of times the words Western Australia mentioned, it comes up 10 times. But that also includes a reference in the table of contents as well. So there you go. Western Australia is mentioned in the Constitution.
Yes, we were definitely a very real state. We've been there since Federation.
Tried to leave, but didn't succeed in that.
Here's a fun one. A Freedom of Information request reveals that there is no evidence that the Federal Court of Australia was legally created, and there is no evidence that the Governor-General ever gave assent.
This one I haven't managed to trace back to its source, so I don't know what the terms of the answer to their Freedom of Information request was. But I can tell you the Federal Court was established by Section 5 of the Federal Court of Australia Act 1976, and that royal assent was given by the Governor-General on the 9th of December 1976 to that Act, and it commenced by proclamation on the 1st of February 1977. Now, the point at which there may be confusion here is that the Governor-General gives royal assent by signing a page at the back of the assent copy of the bill. And what it says is, in the name of His Majesty, or Her Majesty as it would have been then, I assent to this act. And then it's signed by the Governor-General and a date is given. Now, that's done on 3 copies, which are the copies presented for assent. 1 copy is returned to the Office of Parliamentary Counsel as the formal record, and 1 copy is returned to each of the houses. So it depends on very much where you're asking for the assent copy to prove that there'd been assent, but it should be held by the Office of Parliamentary Counsel, and it should also be held by each of the houses of the states. Each of the houses of Parliament.
Well, our next one is also about signatures. Bob Hawke allegedly tricked the British Parliament into passing the Australia Act in 1986 and got a signature of Queen Elizabeth II on it. However, it was at the top of the document, not the bottom. The placement of signatures in law is relevant. Thus, this is an illegitimate replacement to the Commonwealth Constitution.
Oh, good heavens. Okay. Well, for starters, it didn't replace the Commonwealth Constitution legitimately or illegitimately. Okay, the Commonwealth Constitution still exists. Secondly, there was no single trick involved. There are actually really long negotiations of the Australia Acts, and again, showing my bookcase is real and not fake. I actually wrote an entire book about the negotiation of the Australia Acts and the whole history of it and what's in them and are they constitutionally valid and was a referendum required and all of that stuff. So anyone who seriously wants to know about that, book published by Federation Press, 2010. Everything you could ever want to know about the Australia Acts is in there. But for listeners out there, you might want to know what the hell are the Australia Acts. So they were two acts which contain the same substance, one of which was passed by Australia under Section 5138 of the Constitution, and one of which was passed in the United Kingdom by the United Kingdom Parliament. So there are two different acts. And the reason we had two acts doing the same thing was because there was a bit of doubt about whether the Australian one had enough power under its constitution to constrain what the UK people did. So they got both to do it so that one way or another, both acts will cover everything. So you don't need to know which act is working in a particular circumstance because they both say the same thing and they constrain both the United Kingdom Parliament and what happens in Australia. Now, in terms of assenting to these things, there's two things going on here. One is royal assent, which is the actual technical assent to the act, which makes it an act. And one is also known as Queen's consent. And that arises because if you're making a law that affects the prerogatives, the executive powers of the monarch, excuse me, your cough seems to be catching. If one is affecting that, then as a matter of convention and politeness, you get the Queen or the King now to consent before you do the bill. So the Queen gave her consent to the Australia Acts on 3 occasions. First, in relation to formal advice from Prime Minister Bob Hawke on the 7th of August 1985, and that was in relation to the proposal to enact the Australian legislation. Then, on the 15th of August 1985, she gave consent in relation to formal advice from the United Kingdom, so that was from Baroness Young regarding the proposal for British legislation. And third, she gave consent in relation to the effect on her royal prerogatives upon the advice of Sir Geoffrey Howe before the UK bill was actually introduced. So that's the consent stage. And then finally, the Queen gave royal assent to the UK Australia Act on the 17th of February 1986, after it had passed there. And the Queen doesn't actually, unlike the Governor-General, she doesn't sign the bill. She actually signs advice from the Privy Council, which says this list of bills is ready to receive royal assent. And so she just signs that. And that's what gives royal assent to bills in the UK. So the process is different from here. So that's where the assent to the UK version of the Australia Acts is. In relation to the Australian version of the Australia Acts, that was actually given royal assent by the Governor-General, not the Queen. But people get confused about that because you've seen, all of us have seen, and you might even be able to put up a picture of it, but there's this photo of the Queen sitting there signing something with Bob Hawke standing behind her. And people think that she's giving royal assent to the Australian version of the Australia Acts. She's not. She's actually signing the proclamation for the commencement of the Commonwealth version of the Australia Acts because they needed to make sure that the British version and the Australian version started at exactly the same second. So you had all the time zone issues and everything. And so they had to specify an exact time for both of them to start so that it was simultaneous. And so the bit where the Queen has signed on the top of the page, it's not royal assent to the Australia Acts, it's actually her indication that she has agreed to the proclamation for the commencement of the Commonwealth version of the Australia Acts. And as a matter of practice, yes, she does sign at the top. She does that for all sorts of documents. Don't know why, but she does it for letters patent, and anything you see where the Queen signs something is almost always at the top. Maybe because she's very important, who knows?
Oh, this one's fun. The Australian government is a corporation registered in Washington, D.C. These corporations create corporate policies called statute law, which is not real law, only the colour of law. Red, perhaps. The AEC is also a corporation. McDonald's is a corporation. Therefore, they have the same degree of imaginary power as the so-called Australian government. The legitimate government of the Commonwealth of Australia is the real government of Australia, the one that our forefathers fought and died for. But our courts do not recognise our common law Commonwealth Constitution 1901.
Okay. The government being a corporation registered in Australia, if you chase that one back, and there have been fact-checking things that I've given some advice to, I think AAP did one, you chase it back, there are some documents that people refer to, and that is because the Australian government has been registered with the US Securities Exchange Commission. And so people just assume that that somehow turned the Australian government into a corporation registered in America. But the thing is, if you read the document, don't just look that there is a document, read the document. If you read the document, it says that the Australian government is registered as a foreign government, because that's what it is. It's a government, and it's foreign if you're in the United States. So the Australian government is registered in the United States as a foreign government. Why? Because you have to be registered in order to be able to sell certain bonds and financial instruments to US buyers. So if you want to get any US investment, you have to be registered. But they're not registered as a corporation. They're registered as a foreign government. The Australian government is not, by definition, a corporation. In terms of the rest of the statement, it's pretty much gibberish. What is this common law Commonwealth Constitution 1901? One can only assume what they're referring to is the British Act of Parliament, which is the Commonwealth of Australia Constitution Act 1900, because that's when it was passed, and that our Constitution is Section 9 of that Act. Now, both of those fall within the category not of common law, but of statute. Okay, so the common law is inherited judge-made law, and common law is overridden by statute, and statutes are overridden by the Constitution. So describing something as our common law constitution in this context doesn't really make a whole lot of sense. The Constitution is still the thing that I showed you before, the relatively short thing. It overrides statute, and both of them override the common law. So there you go.
Yes, I also like the comment of that, like, our forefathers fought and died for the Constitution, which is interesting given the context. Henry Park said, what the Americans have achieved through war, Australians can bring about in peace, when arguing for us to federate. Though, who knows, maybe Sir John Forrest got into a bit of a scuffle and punched Edmund Barton, I don't know. Who knows? Well,
in the colonial times, they were quite sort of entertaining. Certainly, one of the South Australian found one of the frames of the Constitution, Kingston.
Yes.
Involved in a duel in South Australia. Well, no, sorry, he tried to get involved in a duel and he got dobbed in.
I love that story. Richard Baker was his arch nemesis. This one is a long one and it'll cause you psychic damage. This is in reference to the dual citizenship crisis of 2017. And the claim is, the Constitution is and has the force of law because it is a totality of 4 British Acts of Parliament. The 4 acts are the 1901 Commonwealth of Australia Act, the Statute of Westminster 1931, the Consent Act of 1986, and the Public Record Act of 1990. Ask any lawyer what the term subject or citizen of foreign power means in British law, And they will say that foreign power means countries other than the Queen's realms and territories. So while UK and Australian laws have separate citizenships for their respective citizens, that's not relevant to being a citizen of a foreign power. How can Poms or Kiwis or anyone from a Dominion/Commonwealth realm be considered a foreigner when every Australian Act of Parliament mentions these countries, whose constitutions have the same origin of sovereignty, that is to say, British Dominion measured and defined by a constitution? The crisis never needed to have happened, while neither the referendum procedure nor an act of the Australian Parliament can remove the subject or... The referendum can't do that? No, sorry. I'm not debunking this, you are. While neither the referendum procedure nor an act of the Australian Parliament can remove the subject or citizen clause from the Constitution, there is a provision in the 1986 UK Act that specifically allows Canberra to ask Westminster to amend any UK law that has the force of law in Australia. All the Australian government needed to do was ask Westminster for a statutory instrument to remove this clause from the 1901 Act, and this problem would evaporate.
Okay, that is such a confused mess. It takes a bit of time to pull it apart. But anyway, the first thing is the thing about the four acts and whether they're part of our constitution. It's sort of right again, sort of wrong. So yes, we've got our constitution, which is in the Commonwealth of Australia Constitution Act 1900, not 1901. Okay, tick. Statute of Westminster, yes, 1931, tick. That is part of our broader constitution. I'm thinking what they mean by the Consent Act there is the Australia Act 1986. And, well, we really need both of them, Commonwealth and UK, but yes. And as for the last one, the Public Record Act 1990, I thought, what on earth is that? That is actually an act that the United Kingdom Parliament passed that allowed the original copy of the Commonwealth Constitution to sit in a display box in Australia. So that's just an act allowing a physical display copy for museum purposes. It has absolutely nothing to do with the substance of what's in the Constitution, just the location of the original document. Okay. Next point is that no, Australia cannot ask the UK to change British laws so that they operate as part of Australian law anymore. Why? Because of the Australia Act 1986. So this person's got the complete reverse of what happened. So they're saying that the Australia Act allows the United Kingdom to legislate to change our laws, including our constitution, whereas in fact, the Australia Act did the reverse. So it says that no longer can any British law apply as part of Australian law in the future. So if the British decided, hey, today we're going to wake up and we're going to repeal that whole Commonwealth of Australia Constitution Act, would that get rid of our constitution? No, because it applies in Australia as part of Australian law, and the UK can do whatever they like to their law, but it cannot change the operation of these laws now as part of Australian law. So no, you can't do that. Now, as for the citizenship crisis and all the rest of it, and the argument that a subject or a citizen of a foreign power includes British citizens, well, there was a High Court case about this. You may well say that any lawyer will tell you that that's an answer, but the problem is the lawyers on the High Court said otherwise. So the High Court said, no, Australia is now sufficiently independent from the United Kingdom that the United Kingdom now does count as a foreign power. So that was in the case of Sue and Hill. It was about a One Nation candidate, Heather Hill, who was a British citizen but had dual citizenship. And therefore was held to be disqualified by the High Court. So no, it wasn't the case that when the citizenship crisis started, it was because no one had bothered to read the Constitution and didn't understand what was meant in the Constitution by subject or citizen of a foreign power in Section 44 of the Constitution. It was simply that people had read the earlier High Court judgment that said, well, sorry, if you're a citizen of the UK, then you are a citizen of a foreign power.
Turns out that constitutional crisis was not as easily resolved as this random person in the YouTube comments thinks it could have been. What a surprise. Our final comment is genuinely one of the silliest things I've heard, and that's impressive given the list that we've just read out. But our final little comment for you to debunk is, we did not hold a referendum to alter the Constitution to pay the Governor-General in dollars, and therefore all laws signed after 1966 have been invalid because the Constitution states that the Governor-General will be paid £10,000, not dollars, and that the salary can't be altered during his continuance in office. The Constitution was enacted under an imperial crown, hence the legal currency pounds, shillings, and pence, and as we didn't have a referendum to alter this, dollars are legally useless. And this person has also referenced specifically Quick and Garin, page 396 onwards, which we've already established you have multiple copies of, so it's going to be fascinating to learn how Quick and Garin does not back up this person in any way.
Well, a lot of this all comes down to just read the stuff. People will quote it and refer to things, but they never read it. Anyway, so let's just start with reading the provision that deals with the Governor-General's salary. And so this is section 3 of the Constitution. It says, there shall be payable to the Queen out of the Consolidated Revenue Fund of the Commonwealth for the salary of the Governor-General an annual sum which, until the Parliament otherwise provides, crucial words there, shall be £10,000. Okay? Guess what? The Parliament has otherwise provided. No kidding, the people who wrote the Constitution weren't idiots. They knew perfectly well about things like inflation, right? So they weren't going to put anything in the Constitution that tied things to particular amounts of money, knowing that over time things are going to need to change. And so when they did put in things like that, they put in the magic words, until the Parliament otherwise provides. And that means that Parliament can legislate to update the salary of the Governor-General. Equally, they also put into the Constitution, in the powers they gave the Commonwealth Parliament, the power in section 51(12) of the Constitution to make laws with respect to currency, coinage, and legal tender. So that means that the people who wrote the Constitution said, yes, the Commonwealth Parliament can change the currency in Australia. So no, it doesn't have to be pounds, shillings, and pence. And finally, Quick and Garin, rather heavy, but let's have a look. 396. Section page 396 actually involves a discussion about the letters patent, particularly looking at comparing them with the Canadian letters patent. So, yeah, nothing to do with it. But I'm guessing, again, charitably, there's always some level of truth underneath some of these things. If you go to page 400, okay, then it does actually refer to, there's the bit there on the salary of the Governor-General, okay? And what it does there is it refers to the historical notes as to what they were concerned about during the Constitutional Convention debates. And so their real concern was not about preserving, pounds, shillings and pence, etc. It was about making sure that the government couldn't use the Governor-General's salary as a way of trying to manipulate them to do whatever the government wanted by, reducing their salary if they didn't sort of, assent to this bill or something like that. So that's why you've got the bit in there about not reducing the Governor-General's salary during their term. Okay, but that's really all it's about.
I wonder how this commenter reconciles the fact that the Constitution was enacted pre-decimalisation in the UK, because that 10,000 modern pounds would equate differently in shillings.
Apart from all of this, I guess the one thing I would like to say to your listeners is that so many people are out there trying to look for one tiny little glitch that will, at that point, make every single law invalid. Okay, so you've got people saying, oh, Australia signed the Treaty of Versailles, and that meant that it was no longer a colony, and therefore that made the Constitution invalid. Or whatever. And there are a whole lot of different dates or little different things. And sometimes it's the seal that's used, or the oath that's sworn, or whatever. But every single one of these tiny little picky things that people choose, I mean, most of the time they get it wrong anyway, but even if they got it right, even if there was some small little thing that wasn't done that should have been done, do you think that the High Court is going to say, right, every single law enacted since 1918 is invalid, and therefore we have no law valid in Australia? The answer is no. This is never, ever, ever going to happen. Because in those sort of circumstances, there are these underlying doctrines and principles, okay? So there's a doctrine of emergency, for example, or a doctrine of necessity. If the court had to, it would do something to allow the continuance of the rule of law, okay? So let me give you one example. This did happen in Canada. Canada had to have a law in both English and French. They stopped doing that. And the Supreme Court said, okay, you've got to do that. It's otherwise invalid, but you've got 6 months or a year to fix it all up. And so that's what they did. No one's going to wipe out all your law. So whoever thinks that this is going to save them and stop them from having to pay tax or whatever, you're deluded. It's never going to work.
Thank you very much for your time and expertise. Where can people learn more about the Constitution?
The Constitutional Clarion is a good starting point. But also, the many constitutional books behind me, actually reading these things is a good idea, rather than just listening to, well, I shouldn't disparage YouTube videos, because you and I are doing them too, but as a general principle, look for primary documents, like reading the Constitution. Look for stuff that's written by people who actually know what they're talking about, and not stuff that people just found it out for themselves somehow, and that's probably a good start.
And there you have it. I hope that has been enlightening. You've learned a few things about the Constitution. You've learned a few things about people's silly ideas about the Constitution. But if you'd like some actual expert explainers about the Constitution, Professor Anne Twomey's YouTube channel, Constitutional Clarion, is linked below. I recommend checking her out, subscribing, and enjoying her content. And if you're not subscribed to me, why not? Fix that. And also comment down below what you would like to learn about next, or the silliest thing you've ever heard about the Constitution, and don't forget to share so other people can learn as well. Thank you so much to my supporters on Patreon. I'll see you next time.